So, Mr. Jordan, you want to read this for us from her memoir?
Before you can engage the jurors' empathy, put them in the shoes of the accused or the victim. Make them feel the cold blade held against their necks or the unappreciated devotion that might drive someone to steal from a former employer.
Keep going.
In examining witnesses, I learned to ask general questions so as to elicit details with powerful sensory associations. The colors, the sounds, the smells, that lodge an image in the mind and put the listener in the burning house.
And then finally, she closes with this.
It is the particulars that make a story real.
So she doesn't put it in caps in her memoir, but we should remember it in caps because it's so, so important. And again, when I'm talking to undergraduates about their writing, I tell them to strive for 5. I say, look, a lot of your essays just tell me what something looks like. But I also want to hear your essay. I want to get something where I can smell a part of your essay, some sort of touch in your essay, or even taste. And they're all things Sotomayor talks about. So she says, look, the colors. Talk about what the scene looks like. But don't forget the sounds. Don't forget the smells. And she even has touch in there when she says, make them feel the cold blade held against their necks. If you can work in taste somehow, that would be amazing. But at least try to move beyond just the visual. And it's not just at the trial level. At the appellate level, John Roberts says this, Mr. Lewis.
You're looking for a couple of hooks in the facts that hopefully are going to be repeated in one form or another later on in the legal argument, but also are going to catch somebody's interest. Give judges some hook, and it helps draw them into the brief and carries them along a little bit.
And this is what makes the lawyers in the Child Welfare Appellate Clinic such good lawyers, that they give the judges they're writing to some hook. They know that the judges are reading brief after brief after brief. If you can tell them a story to get them involved, potentially you're closer to getting your client the relief they want. And so it's partly that they're really great writers, but when I started working with them, I discovered something, Mr. Lewis, and I discovered this.
What makes them great writers is that they are super great readers.
And so when they're reading through the transcripts, they're looking for the particular moments. They're looking for the hook. They're looking for that image that's going to reel the judges in. And they're going to get rid of all the other stuff. And so they're really good at distinguishing between 2 things, facts and truths. So one way to think about the difference between facts and truth is through a great Italian playwright named Luigi Pirandello. So, Ms. Rachel, you want to tell us what Pirandello says about the difference between facts and truth, or at least what a fact is?
A fact is like a sack. It won't stand up if it's empty. To make it stand up, first you have to put in it all the reasons and feelings that caused it in the first place.
Yeah, and so think about this. I know that a lot of you are still editing your first year memos, and the impulse will be to include everything. But you can't just rely on a regurgitation of what you found. You have to think about, how do I make these facts meaningful? How do I turn them into truth? This is still a little abstract, so let's break it down a little bit more simply, and maybe this is the way to distinguish facts and truth, Ms. Rachel.
Truth. Those thoughtfully selected facts that help the judge make the right decision.
So you can imagine the world, your big world, when you're writing your brief, you're writing your memo, and it's filled with all these facts. What you're searching for are the truths. And what's important is that the truths cannot be outside your record. You can't just say, look, I believe this thing, so you should follow. It has to be inside, but it's not going to be the whole thing. And that's one of the major, major mistakes that students make all the time, is they include too much. They don't know how to separate out, what's that truth? What's that little bit of particular that's going to get the judge on my side from all the other nonsense? And it's something that we can sort of get in a distilled form through the French writer Voltaire. So, Ms. Rachel, you want to try out your French on this phrase?
Le secret d'ennuyer est celui de tout dire.
And now in English?
The secret of being a bore is to tell everything.
And this is a mistake you all make. I get bored by reading your briefs because you include way too much. And so in the Child Welfare Appellate Clinic, we actually have a principle. We call it the need to know principle. And Mr. Jordan, you want to read what the need to know principle is?
What do I, as a judge, need to know to decide in your favor? Everything else, delete.
Yeah, and it's really, really tricky. So what we do is we have them do a first draft that's intentionally longer than we want the final draft. Why do you think we do that? So say the first draft is going to be 10 pages, even though we know the final brief is just going to be 8 pages. Why do you think we give them that chance in the beginning?
It puts you in a good position to sort of critically assess what's essential and what's not.
Yeah, because you don't know at the first draft. So take the pressure off the first draft. Remember, the first draft is going to be about getting all the facts. The second and the third and the fourth draft is figuring out what among those facts are your important truths.